Good morning, everyone. I'm going to go ahead and get started. Thank you, everyone, for joining us this morning for today's Understanding Your Rights as a Student Loan Borrower webinar. This is the fifth and final webinar of our webinar series partnership with Betsy from TISLA. If you missed any of our other webinars, they are all posted on our DFPI YouTube page. We have a PSLF webinar, IDR webinar, repayment options webinar. We won't be talking about any of those updates today, but you can click on our page or go on our YouTube page and you'll see all those webinars. So just a few housekeeping items throughout the entire webinar. Your video, microphone, and chat feature will be disabled. You can enter your questions in the Q&A function, but please wait until we touch on that topic to enter a question, and then also do not enter any personal detailed questions or information in the chat or in the Q&A, since this is a public forum. And then this webinar will be recorded, is being recorded, and will be posted on the YouTube page within the next few days. So next, please. Okay, so my name is Selena Damian, and I am the Student Loan Servicing Ombudsperson at the DFPI. It is my pleasure to be here today with Betsy Mayotte, who is the president and founder of the Institute of Student Loan Advisors, or TISLA. She has been working in the student loan industry for over 20 years and has helped thousands of borrowers with their student loans. She knows a lot. She's like the guru, and she helps me a lot as well. I learn a lot from her all the time. So as many of you know, there have been many changes taking place in the federal student loan landscape, and we have covered a lot of those significant changes in our previous webinars. However, in order to successfully manage your debt, it is also important that you understand your rights and your options and responsibilities as a borrower. So there are a number of federal consumer protection laws that student lenders must follow, including the Truth in Lending Act, TILA, the Equal Opportunity Act, the Fair Credit Reporting Act, that have to do with lenders or for the lenders. But these laws together provide a number of protections for consumers. So those are consumer protection laws. But there are specific student borrower protections, and that's what we're going to be talking about today. So we're going to be talking about federal protections, and then we will be talking about state protections for student loan borrowers. And then next, please. As I said, questions can be posted in the Q&A, and then please do not ask the questions until we have covered the topic, and then please do not ask any detailed questions. Next, please. And just briefly about DFPI, we are California's Consumer Protection Agency, and we regulate companies of financial products, and that includes student loan servicers. Just briefly, student loan servicers are the companies that manage borrowers' accounts. So those are the companies that the Department of Education contracts with to send out bills, to process applications, to track borrowers' account history. So those are the borrower's main point of contact. At the DFPI, we also accept and evaluate consumer complaints, take enforcement and legal actions when companies are not in compliance, and then conduct education and outreach, such as this one, to protect consumers from fraud and abuse. Next, please. And then TISLA is a nonprofit agency that offers free expert unbiased student loan advice, and they are nationally recognized experts. And there's the email, and we'll post it at the end as well. Next, please. And then I will hand it over to Betsy to get us started on federal rights.
Thank you so much, Selena. I also want to, in addition to thanking Selena and DFPI for partnering with us on this series of webinars, I want to thank the Rose Foundation, who provided the funding to allow us to offer this series of free webinars. And I'm delighted to say that they actually offered to fund another series of free webinars that we will be partnering together to offer in 2024. So keep an eye on the DFPI website to find out the dates and topics of those particular webinars, as well as Selena mentioned, a link to their YouTube channel, which has the recording, will have the recording of this webinar, as well as the ones that we already completed in 2023. So I want to, the last housekeeping thing, and I did have it on the prior slide, but it's important to emphasize this. Selena and I are not attorneys, so we cannot give legal advice. So keep that in mind when you're asking your questions. Is that we cannot give legal advice as part of this presentation or otherwise. Okay, so I want to start out with your rights under the Federal Student Loan Master Promissory Note. Federal student loans are a unique animal in several ways. And the way you get a federal student loan to start with is one of the first places where it's really unique to other different types of consumer debts. In order to take out a federal student loan, you do have to sign what's called the Master Promissory Note or the MPN. Now that you might be saying, well, that's not unique. You usually have to sign a promissory note when you take out any loan. Well, what makes this process unique um, what makes this process unique is that as opposed to most consumer debts where you're signing a promissory note every time you take a new loan, that's not the way the MPN works. In order to make the process of obtaining financial aid easier, back in the year, I think it was the year 2000, they started this NPN process. And what it means is that for most borrowers that are attending college or university and that are taking out federal student loans, you're actually only ever going to sign one promissory note. The master promissory note is good for multiple loans. There's no limit to the amount of money that can be borrowed under the MPN other than the regular federal annual and aggregate maximums. And there's no limit to the actual number of loans that can be obtained under that single master promissory note. A master promissory note in most cases is good for 10 years. So unless you're attending school over a period of time that's longer than 10 years, you're probably only ever going to sign this one note. Now, there are exceptions to that, of course. If you sign a master promissory note and actually don't end up taking any loans out within the first 12 months after you sign it, then they put it aside. And if you go to take out a student loan later, then you will have to sign a new one. Colleges and universities also have the option to require you to sign a new MPN, but that's not common for them. That's not common for them to do that. Now, one of the downsides to the master promissory note process is there's no loan amounts on it. Because you're signing a note that can be good for up to 10 years worth of loans, there's no actual loan amounts on it. So people, like, normally if you want to verify how much you borrowed, you'd ask for a copy or you'd look at your own copy of your promissory note, say for a car loan or for your mortgage, to see how much you initially borrowed. The master promissory note is not going to show the loan amounts. In order to see how much you initially borrowed, the place to go is the Department of Ed's website, which is studentaid.gov. Your loan servicer will also list the original amount that you borrowed. Now, the way you ask for a loan on an annual basis, so just to be clear, even though the master promissory note is good for multiple years and multiple loans, that doesn't mean that loans are just going to be assigned to you without you initiating it and sort of cross-checking that you do want the loan. The way the master promissory note process works is you initially indicate your desire to take out a federal student loan during the annual FAFSA process. So every year that you get federal student aid, you have to fill out the free application for federal student aid. And one of the questions on the FAFSA is I want student loans. And so if you check that box and you already have an MPN, that's pretty much all you're going to, for the most people, all you're going to have to do to get your loans for that year. Now, if you check that box and you have an active MPN, that doesn't mean that you have to take the loan. The next step in the new loan process under the MPN is the award process. Now, some schools use what we call an active financial aid award process, and some of them use what we call a passive financial aid award process. When a college or university processes your financial aid package, you get what's called an award letter. Now, the award letter is going to list any grants or institutional scholarships that you might be getting, and it's also going to list the maximum amount of loans that they're potentially awarding you for that year. Now, if the school has what's called an active process, in order to accept the loans, they're going to require you to do something. That could mean logging into your university account and checking a box or clicking yes somewhere. It could mean sending an email to the financial aid office. Whatever their active process is will be outlined on that award letter. Now, if the school has what's called an active process, you still can reject the loan down the line. Um, Under an active process, you have up to 14 days after the loan is dispersed to your school to say, I don't want this loan, or I want less of this loan. Now, if the school has what we call a passive process, and more schools utilize a passive process than utilize an active process. Excuse me. If the school utilizes a passive process, basically what they send you your award letter, and in the award letter it says, if you're okay with all this aid, then don't do anything. If you're not okay with any of this aid, then do this. So essentially they're taking no answer as a yes under the passive process. Now the flip side to the passive process is you actually have a longer amount of time to cancel the loan after it's been dispersed. If the school's using a passive process, you actually have up to 30 days to cancel the loan after it's been dispersed to the school. And there's no penalty to you to cancel the loan within those windows, whether it be the 14-day window or the 30-day window. You're not going to be charged any interest. Any associated origination fees will be backed off. There's no penalty to you at all. Now, you could very well still owe a bill to the school that was originally covered by the loan, but you pardon me, but there's no otherwise penalty for canceling the loan during that period. Now, as I mentioned, even though the master promissory note doesn't have loan amounts and is good for multiple loans, there are still multiple ways that you are notified of the amounts you borrowed. As I mentioned, you do get notified of the amount that you're borrowing through that award letter. After the loans are dispersed, the amount that you borrowed is listed on the Department of Ed's website, which is studentaid.gov. Anytime you drop below halftime in school, whether it be because you graduated or because you dropped some classes or you outright withdrew, you're going to be requested to go through something called exit counseling. It's highly recommended that you go through this exit counseling, but if for some reason you don't, the school will mail you the exit counseling materials, and part of those exit counseling materials is a listing of all your federal student loans that you borrowed. And then finally, of course, you can always check your loan servicer's website, because that's going to show you not only how much you originally borrowed, but how much you owe today. Now, here's a little pro tip. Even after that cancellation window is over, whether it be the 14 days or the 30 days, any money that you pay towards the loan within 120 days of the day it was dispersed to the school, they're going to treat it like you never borrowed it in the first place, which means that any interest that may have accrued on that loan will be on the amount that you paid will be backed off, and any origination fees that are associated with the amount that you paid will be backed off. So for example, let's say you borrowed a $10,000 federal student loan, and then within 120 days of that loan being sent to the school, you send in a payment of $1,000. They're going to treat it like you only ever borrowed $9,000 to begin with. So any interest that accrued within those 120 days on that $1,000 portion, they're going to get rid of it. And the small percentage of the loan that's taken off for origination fees that's associated with that $1,000 is also going to be backed off. Before I get into the next section, Selena, were there any questions that have come up that you think might be good for the whole group to hear?
No, not yet.
Okay, thank you.
You're welcome.
All right, so now that we've talked about your rights under the master promissory note, on the loan origination side, I want to start talking about your rights regarding the payments that you make on your federal student loans. Now, your federal student loans, whether it be a Parent Plus loan or a federal consolidation or a Stafford loan or a Graduate Plus loan or a Perkins, is going to be deferred, meaning no payments are going to be actively due as long as you're considered at least half-time enrolled in school. Now, the definition of half-time enrolled is different depending on the school, but most schools literally use half of whatever they consider full-time. So if full-time is considered, say, 12 credits, for many schools, half-time would be considered 6 credits. Graduate programs, they tend to be a little more lenient as to what, or generous as to what they consider half-time. I've seen a lot of graduate programs where they consider even one class to be considered half-time. If you're at least half-time in school, the school's required to report your current enrollment to the Department of Education and the loan servicers on a frequent basis, and they're required to report it even if for some reason you told them not to. Now, once the servicer is notified that you're at least half-time in school, they're going to automatically put an in-school deferment on the account. So there's nothing you have to do to defer your loans. Parent Plus loans are deferred if the student for whom the Parent Plus loan was taken or the parent borrower themselves is at least half-time in school. As far as making payments go, you can make payments at any time. There is never, ever a penalty for paying extra on your loan or paying when you're not due for a payment. And, for that reason, we encourage borrowers to make payments while they're in school, at least the interest that's accruing on their loan, even though they may not be getting a bill for it. Again, there's no penalty. And the faster, for the most part, the faster you pay down your loan, the less you're going to pay out of pocket over time. The only exception to that rule is sometimes in bankruptcy status, and that's not necessarily a rule under federal student loans, but it could be a requirement under your pending bankruptcy that you not make any payments to any creditors. So if you are in a bankruptcy status, you will want to check with your bankruptcy attorney or the court or the bankruptcy court to see whether you're prohibited on making payments on your student loans. Now, one thing you don't have the right to is to dictate what amounts of your payment go to principal and interest. That is codified in federal regulation. With the exception of payments that are made by the Department of Defense. So, for example, if you were in the military and you're getting a student loan repayment benefit because of it, with the exception of those payments, all payments are required to first go to any outstanding late fees or collection costs you might have. Now, these days, you're only going to have those if your loan is in default. Once those are paid down to zero, or if there aren't any, they're required to put any money of your payment towards interest that's accrued as of the day that you made your payment. Now, once that column is brought down to zero, any money left over will go to your principal balance. Now, this might cause a little confusion, especially with a new repayment plan that's out there called the SAVE plan, where that can, if your payment is low, might offer you an interest subsidy. But that doesn't change the way payments are applied. So again, payments always have to go first to any late fees or collection costs, then interest, then principal. I do get questions fairly often where borrowers are asking, maybe they're making an extra payment, that they're asking that the whole payment go only to principal balance. And unfortunately, that's not allowed. As long as there's money outstanding in that interest column, they are required under regulation to pay that down before any money can go to principal. Now, with that said, if you are paying extra, you absolutely have the right to dictate what loans any extra funds are applied to. So let's say you have 5 loans, and some of the loans have a higher interest rate than the other loans do, and you're making a payment that's over and above what you're being billed for, you can tell the servicer where to put that extra money. So, for example, if you're paying, say, if your monthly payment is $300 a month and you're sending in $500, you can say that you want that extra $200 to go to loan number 1. Let's pretend loan number 1 at a higher interest rate than the other ones. You can absolutely dictate that. Now, some of the servicers make that easier to do than others. Some of the servicers have a way for you to actually make that request right online. So if you're making your payment through the servicer's portal online and you're making an extra amount, you can dictate where that extra amount, which loan that extra amount goes to right online. Other servicers you do have to call and ask them to reallocate that extra amount to the loan you want it to go to. All right, let's talk about information sharing. This actually comes as a surprise to a lot of people, especially these days where information security is very different than it was even 10 years ago. If you read the language on your master promissory note, you'll see that by signing the MPN, you're actually agreeing for your information to be shared in quite a few places. And most of them make a lot of sense. By signing the master promissory note, you're agreeing that your loan information can be shared with colleges and universities, and that includes colleges and universities, a school that didn't get the loan that they're getting information about. So, for example, let's say you went to the University of Salina for your first 2 years and you took out loans, and now you're transferring over to the University of Betsy. The University of Betsy has access to all your loan information from the University of Salina. And the reason for that is they need that information to award you additional financial aid because they're not allowed to award you more than you're eligible for. Therefore, they need that prior loan information to do it correctly. They also need to make sure that you're not in default or severely delinquent on your other federal student loans before they can award you additional money. So that's why there's information sharing allowed amongst colleges and universities, even schools that aren't directly involved with the loans in question. Of course, you're agreeing that the information can be shared with the Department of Education, but that also includes all of their vendors. That means all their loan servicers, any other contractors or other vendors they have, other federal agencies, and others that are allowed access to that information under federal or state law. So, for example, all federal agencies have access to whether or not you have defaulted student loans because most federal agencies prohibit you being an employee of theirs if you do have a defaulted federal student loan. So that's one example where maybe the Department of Agriculture might have access to your loan information if you're applying for a job there or if you're an employee there. Your immediate family, they're allowed to disclose information about your student loan. That includes your spouse, your mother, your father, perhaps even your siblings. Now, your immediate family is one area where you can request in writing that your loan information not be shared with them. But unless you do submit that in writing, they can share your loan information with your immediate family. They can also disclose your loan information onto the references that you included on your promissory note. Now, when you filled out your master promissory note, they required you to supply 2 references. The purpose of that is not to look at your credit or whether you're eligible for the loan. The purpose of those references is if you ever fall off the grid, so to speak, if they're trying to reach you and they find that your address is no good, the mail comes back as undelivered, and your phone number is no good, and they initiate skip tracing and they're unable to connect with you. That's the purpose of those references. If you never go delinquent on your loan and you always make sure that your loan servicer has your up-to-date address and phone, they will never ever reach out to your references. But if you do go delinquent and they can't reach you by email or phone, they will reach out to those references, and they can, as part of that, disclose loan information to them. Now, as I mentioned, out of all of these things, the only thing that you can prevent is having your immediate family have access to your loan information. And if you wish to do that, you would need to send that request in writing. Some student loans have the right to have some of the interest or some or all of the interest subsidized, meaning waived during certain periods. Subsidized Stafford loans, which today can only be taken out by undergraduate students. Prior to 2012, graduate students could also get subsidized Stafford loans, but as of 2012, that's no longer the case. Subsidized Stafford loan, the government pays the interest while your loan is in an in-school status or in-school deferment or any other deferment. They pay it during your grace period, and also they provide some interest subsidies during some of the income-based repayment plans. Now, it wouldn't be student loans if there weren't exceptions. If you have subsidized Stafford loans that were taken out between 2012 and 2014, they don't offer a subsidy during the grace period. That was something that Congress did in the law and then took away. If you took your loan out between 2013 um, and 2023, there was a possibility that there was a limit to your interest subsidy, but that has since been repealed. That was repealed earlier this year. Now, Perkins loans work the same as subsidized Stafford loans. No interest accrues while you're in deferment or while you're in school or grace period. Now, any other loan other than a subsidized Stafford loan accrues interest from the very moment that it's dispersed to the school. So as soon as that money's dispersed to the school, you're accruing interest off of whatever the outstanding balance is that day. So to be clear, if you took out a $10,000 loan, 99% of all loans go out in two disbursements, one in the fall and one in the spring. So in the fall, for your $10,000 loan, $5,000 would get dispersed to the school. Let's say that got dispersed on September 1st. On September 1st, you'd start accruing interest off of that $5,000. And then let's say on January 1st, they dispersed the other $5,000. As of January 1st, you'd be accruing interest off of the full $10,000. Interest accrues off of whatever the outstanding balance is as of that day. So anytime you pay the balance down, you're accruing less interest the next day. If your balance should go up due to interest capitalization, then the next day you'll be accruing a little bit more interest. If that's confusing to you, I recommend that you go into the DFPI YouTube channel and look at our student loan fundamentals training, because we talk a lot about interest accrual and payment application there. Now, one of the myths around student loans is that the interest compounds daily. It does not. Interest is not added to the principal balance except in these days, very rare situations. Interest accrues in its own little column. So let's say you're accruing $1 interest a day. Let's say you owe $5,000 and you're accruing $1 a day in interest. Today, you're going to accrue $1 off of that 5,000, and that dollar is going to sit in its own little column. Tomorrow, you're still only going to accrue $1 because they're accruing it off of that $5,000. They're not accruing interest off of whatever's in that interest column. Again, if you're finding this a little confusing, I strongly recommend that you check out that particular webinar, because we cover all of the interest accrual and payment application in great detail. Now, as far as your interest rate goes, the interest rates are set by Congress. Any loan taken out since 2006 has a fixed interest rate. Some borrowers have interest rates below 2%. Other borrowers have interest rates that are, if they have loans taken out in the 80s, I've seen federal student loan interest rates over 9%. The average student loan interest rate these days is in the 4 to 6% range. But if you are active duty military, the SCRA, which is the Service Member Civil Relief Act, caps your interest at 6% during any period where you are active duty military. Now, you shouldn't have to take any action for that to happen. If you're active duty, the servicer should automatically, and your interest rates are higher than 6%, the servicer should automatically adjust that during your active duty period. Now, your student loans are automatically dispersed directly to the institution. And the institution is then going to use those funds to pay what we call direct costs, which is really your tuition and fees. If there's money left over, they will send that money to you in the form of a refund. Now, you have the right as a student loan borrower to use that refund for anything related to your education. That includes your room and board, books, supplies, rental or purchase of a personal computer, transportation, dependent care expenses, commuting expenses. You do not have the right to use that student loan money or that Pell Grant money for anything that's unrelated to your education. That includes credit card payments. That includes um, say, my mind is drawing a blank. Um, so credit card payments wouldn't be allowed. Uh, Payments towards, in some cases, using it to buy a vehicle is allowed. In other cases, it's not. It depends on whether your school baked in the purchase of a vehicle into your cost of attendance. You can't use it to pay off other debt. Those are not allowable educational expenses, and you do not have the right to use your loan money for those purposes unless it's related to your education. Now, you do have the right to lower payment options if you're eligible for those particular options. So that includes plans such as the extended repayment plan, the graduated repayment plan, consolidation, what we call the income driven plans, which includes income based repayment, pay as you earn, the save plan, which used to be called repay, and income contingent. Now, again, if you're eligible for those plans, the servicer is not allowed to deny you that plan. But let me give you an example. The pay as you earn plan, Parent Plus borrowers are not eligible for pay as you earn. So if you applied for that, they can and they will deny you the pay as you earn plan because under federal law and regulation, Parent Plus loans are not eligible for that. If your loans are already consolidated and you don't have any other outstanding loans, in most cases, you're not allowed to reconsolidate. So you could be denied consolidation for that reason. But if you're eligible for the plan, that you have the right to that plan, and the servicer cannot deny you that plan. Before I get into the other options, if people are struggling with payments, I just want to check in with Selena to see if there's any questions on stuff we've covered so far you think I should address.
No, we do have one question. No, a question was asked, can use of funds, I'm assuming the loans, also be a tax write-off? Which I would say no, but I believe that was the question.
Yeah. So there are actually a lot of tax benefits related to higher education expenses and student loan payments. Utilizing your student loans for educational purposes is not a tax write-off. If you pay other expenses out of pocket, not using federal aid money, then if you're eligible for them, there are some tax credits and deductions that you can use. I recommend that people go to irs.gov and check out something called Publication 970. That's 970. That covers all of the higher education related tax credits and deductions. But again, if you got a student loan refund and you use that to pay for your books, you can't use it as a credit or deduction. But if you paid out of pocket for those books, if you're otherwise eligible for that credit or deduction, you would be able to. That was a great question. Thank you.
Thank you. And I'm putting the link to that publication in the chat.
Awesome. All right. So there's other options if you're struggling with your payments other than the lower payment options. There's two buckets. They're called deferments and forbearances. Now, as far as your rights go as a borrower, you have the right to a deferment if you are otherwise eligible for that deferment. The servicer, or in the case of a FFEL loan, the lender cannot by law deny you that deferment if you're eligible for it. Forbearances, meaning the type of forbearance that you would call and say, I'm struggling with my payments, I want to put my payments on hold. That is, you do not have the right to that. They'll often be granted, but in the case of direct loans, the Department of Education, on behalf of the servicer, can and sometimes do deny the use of a forbearance. So for deferments, the difference between a deferment and a forbearance is if you have subsidized loans, no interest is going to accrue while you're under deferment. Some reasons for deferments include being unemployed and actively seeking full-time work. Um, Economic hardship deferment are for people in the Peace Corps or people receiving some sort of federal or state assistance, or people who their income is less than 150% of the poverty line of their family size. Other deferments are related to, say, being in a rehab facility or being under a fellowship, like a medical fellowship, are some other reasons for deferment. Now, many of those deferments are limited. So, for example, unemployment deferments, you're only allowed 36 months throughout the life of your loan. If you hit that 36-month limit, you're no longer eligible for it, and therefore you no longer have the right to it. But if you're working less than 30 hours a week, haven't used your maximum unemployment deferment, and you're actively seeking full-time work, that deferment is your right, and the servicer can't and won't deny you access to it. All right, so let's talk about some possible defenses to repaying your loan. So most of these show up in the form of what we call discharges. And you can find out more information about all these discharges either at the Department of Ed's website, which is studentaid.gov, or the TISLA website, which is freestudentloanadvice.org. Under the Department of Ed's website, it's under forgiveness. And under our website, it is also under the tab called forgiveness. And then you can see discharges. So you do have the right to get your loan discharged if you meet the definition of total and permanent disability, which is in general means that you are unable to work for at least 5 years due to an illness or an injury. You can also get a disability discharge if you are receiving Social Security disability benefits that only need to be reviewed no more often than every 5 to 7 years. And finally, you can get a disability discharge if you're considered 100% disabled by the Veterans Administration. You also have the right to a discharge if the borrower of the loan should pass away, or in the case of a Parent Plus loan, the student for whom the Parent Plus loan was taken. If the school committed fraud through misrepresentation related to their educational program, you have the right to a discharge of, in some cases, partial or all of the loans associated with that program. To be clear, now that particular discharge is called borrower defense. To be clear, you can only get a discharge if they misrepresented something related to the educational program. So, for example, if they advertised that the program had a 90% job placement rate, when in reality it was a 10% job placement rate, that could be a reason for borrower defense. But if, let's say, you got kicked out of the program, or you failed out of the program, or you felt like you were being discriminated against, or you fell down the stairs and injured yourself, none of those are, you might have a claim through another legal avenue, but none of those are a reason for the borrower defense discharge. Another reason that you have the right to get your loans discharged is if you did not have your high school diploma or GED at the time you took the loans out and the school knew that. Now, I emphasize that last part because I've reviewed my share of claims like this over the years, and there's been some occasions where the borrower has filed this discharge, and it turns out when you looked at the borrower's application to the school, when the school asked them in writing if they had a high school diploma, the student said that they did. So that would not be a case that would be eligible for discharge, because in that scenario, the student lied to the school about having the high school diploma. Therefore, the school had no way of knowing that there was no high school diploma. But if the school knew that you didn't have one and they gave you loans anyway, then you have the right to have those loans discharged. You have the right to have your loans discharged if, when you attended the program, you had some sort of status that would prevent you from practicing in your field. So here's a real life example of why this rule exists. Back in the 80s, here in Massachusetts, there was an entity called Andover Truck Driving School, and they committed a lot of fraud when it came to student loans. But in particular, they actually brought people in off the street and had them sign up for student loans. And it turns out that some of those people were legally blind. Now, if you're legally blind, you can't get a driver's license, never mind a truck driving license, under state law. So therefore, that person had a condition that meant that they would not ever be able to benefit by state law for that truck driving program. Now, that's an extreme example. A more updated example might be if your state prohibits you from practicing law if you have a felony. Another common example is if you are convicted of some sort of sex or juvenile related abuse crime, you're unable to work in childcare. So if your state has a law like that and the program is specific to that, and your school is aware that you have that pre-qualifying condition and gives you loans anyway, then you have the right to get those loans discharged. Um, if someone is convicted of forging your name on the promissory note, if you withdrew from the school and the school should have given a refund and they did not given a refund of your loans and they didn't, or if the school closed within 120 days of your attendance and you were unable to complete your degree. Now, you are still required to pay if you didn't get a bill, if you can't afford the payments. Now, thankfully, there's a lot of options out there if the payments are unaffordable to you. If you are under 18 when you sign the promissory note, there is no what they call defense of infancy when it comes to federal student loans. I've seen 15-year-olds that signed master promissory notes because they started college early. While it is possible to get your student loans discharged in bankruptcy, it is still difficult to do that. So you may still be required to pay even if you did file for bankruptcy. If the school closed after you left, you are still required to pay, and you are still required to pay even if you didn't get the job or salary that you were expecting. All right, the last couple of things I want to cover before I swing it over to Selena. You do have the right to access your payment history at any time. If your loan has changed servicers, it may take a while to get a full payment history, but your payment history with your existing servicer is accessible right on the servicer's website. Now, if you consolidated your loan, depending on how long ago it was, you may not have the right to your payment history pre-consolidation because that's a whole new loan, and they're only required to keep records of the underlying loans for 5 years after you consolidated the loan. You 1,000% have the right in the event of a dispute to request assistance from any entity you are comfortable with requesting assistance from. Now, in front of you, there's a list of all the possible places to start with to file a dispute. I suggest that you don't necessarily start with what I call the nuclear option. Most disputes can be handled really simply and sort of with the low-hanging fruit. So in most scenarios, I recommend that you start by writing an email or a snail mail letter to the loan servicer with your dispute. That will resolve most of them. Sometimes even a phone call will. Most of the servicers have an ombudsman unit or an escalated customer service unit. That would be my next step, would be to reach out to them. From there, I would go, if you're still not getting the dispute resolved, and by the way, unfortunately, you're going to have patience, especially right now. Disputes can sometimes take months to resolve, especially the more complex ones. If you're still not getting satisfaction, you can file a complaint with the Department of Ed's ombudsman or with DFPI. TISLA, you're not really filing a complaint with us, but we do help people with disputes, sometimes by stepping in on their behalf to advocate for them, sometimes by teaching them how to manage a dispute. You can also file a complaint with the Consumer Financial Protection Bureau or with your member of Congress. Now, you do have the right to appeal most decisions that are made by your loan holder. But keep in mind that they are not allowed to change law or regulation. So if they're doing something that's based on law or regulation or through instructions by the Department of Ed, you can dispute it, but they're not going to be able to change the answer. And you also have, if your loan is in default and you're being subjected to wage garnishment, you do have the right to appeal that. Now, with great power comes great responsibility. And with all those rights, you do have responsibilities as written in your promissory note as a student loan borrower. It's your responsibility to ensure that your loan holders have your correct contact information at all times. It's your responsibility to read every piece of snail mail and email and respond in a timely manner if necessary. It's your responsibility to notify your loan holder if you leave school or if you've gone back to school to make your payments on time, regardless of whether or not you've received a bill, to keep your own good records, and to read all the requirements and consequences of any lower payment options, discharge, or other program. And with that, unless there's other questions you want to share with me, Selena, I'm going to throw this over to you.
All right, thank you. That was great information. No, we don't have any additional questions. I don't see any, and I did include all those links, the links that you mentioned in the chat for borrowers or for participants, viewers. Next, please. So now that you heard about your federal rights under through the federal government, some states, California is one of those that has established additional protections for borrowers because of everything that was going on, and just there is a need, right? So states have stepped in and created these laws. And as the California Consumer Protection Agency, we are the ones who have been tasked with enforcing those laws. So a few years back in 2019, the state of California passed the Student Loan Servicing Act, or what we call SALSA. And basically that was a requirement that all student loan servicers, federal or private, had to be licensed through the state. A few years later, then the California Consumer Protection Law was passed, the CCFPL, and that was a more broader consumer protection law to protect California consumers. Well, in 2021, we passed an additional law to provide more specific rules for servicers. This is a California Student Borrower Bill of Rights, Assembly Bill 376. And basically this law, what it requires is it prohibits servicers from engaging in deceptive, unfair, and abusive practices. And it requires that they work in the best financial interest of borrowers. So not only does it require that they follow all the federal regulations, but it does require there's payment processing requirements that servicers must process student loan payments in a timely fashion. Any overpayments must be allocated in a manner that reduces the total cost of the student loan. So overpayments and partial payments, again, they have to be applied in the best financial interest of the borrower. Late fees are capped at 6% of the amount past due. Servicers must ensure that they timely and correctly process IDR applications and other paperwork for federal student loan benefits. So as you heard, they have to access or provide you access, allow you to enroll in the plans. The California law basically says that they have to process them in a timely and correct manner. So it builds upon those existing laws. Specifically, they also have to provide training to their customer service personnel for military borrowers, those working in public service, older borrowers, and borrowers working with borrowers with disabilities. So basically, if a borrower that's calling about PSLF, a borrower that's calling about other benefits, TPD applications, they have to be able to provide accurate information and provide those applications also in a timely manner and help you process those. Next, please. And then this is really important, especially right now with the repayment restart. This law protects borrowers from any negative consequences stemming from a sale, assignment, transfer, system conversion, or payment made by the borrower, made by the borrower to the original student loan servicer. So basically, if there was a transfer of your student loan, which there were millions of transfers during the COVID payment pause, a borrower cannot incur any negative consequences. This includes negative credit reporting, any late fees not required by the promissory note, loss or denial of eligibility for any benefit or protection established under federal law. So basically, with if your loan was transferred, and let's say your PSLF tracking was something happened where the account was lost, or they lost your IDR application that you had submitted, or they put you under. So any negative consequences that you incurred, which we are seeing some happening, you are protected from that. Betsy talked about them responding in writing in California. If you write to them or file a QWR, which can be in writing, email, or phone call, they have to respond within 30 business days. One very important provision in the Bill of Rights is that a borrower has a right to take legal action against their servicer if they fail to comply with these laws. This is called a private right of action. We have yet to see a borrower file one, but we have been on payment pause for 3 years. So under this private right of action, a borrower or consumer who suffers damage as a result of the failure of the servicer to comply with any of these provisions has a right to obtain or recover treble damages, restitution, punitive damages, or attorney's fees. So this is a very important provision in the bill. Next, please. And then even most recently, the Private Student Loan Collections Reform Act. So this applies to private education lenders or private education loan collectors. So what this law specifies is that a lender or collector may not initiate a private education loan collection action unless they possess certain documents. And I didn't list them on here because there's 18 of them, but basically they have to provide the name and owner of the private education loan, creditor's account number, any information of the original loan or the original account. So what was happening was that these loans were getting transferred, and then years later, or accounts were being transferred. This is for private loans. Years later, collectors were going and filing legal actions against borrowers when they didn't have all the necessary documents to file these actions. They have to have the payment history. They have to have the when the loan was incurred, or any documents related to the original loan. Additionally, a court may not enter a judgment in favor of the lender or the collector unless these documents are introduced, and they have to provide the documents to the borrower as requested. Again, any person, consumer, borrower who suffers damage as a result of a failure of a creditor to comply may bring an action against the creditor for damages, including punitive and treble damages. So this is, again, just more protections and rights of borrowers here in California, and they pertain to not just federal student loans or federal borrowers, but also private loans. Next, please. And then how can we help? I know Betsy talked about it, what your steps of action is. Right now, it's very hard to contact servicers. So in order for us to be able to monitor what's going on in California with servicers, to see if we need to jump in and take enforcement actions and really hold these servicers accountable, I am really recommending, advising borrowers to get anything in writing, to get every document, every communication in writing. If you are calling your servicer, trying to obtain information on PSLF, on your payments, on your if you're not getting responses, unapplied payments, payment amounts, any of these programs, you can file a complaint through us. So when you file a complaint through our department, they have to respond within 15 days. Right now, they are taking a little bit longer because of the repayment restart, but I monitor all the complaints that are coming in, all the responses, to make sure they are responding in a timely manner, to see that they are responding appropriately, and that they are resolving consumer or borrower issues. So it's a really important avenue for resource for borrowers to have. So once I review the complaints, I also work with the FSA Bud's office, and I can elevate those complaints for resolution. Again, everything is taking longer, so this is a process. You do have to be patient, but you want to be tracking any communication in case there are issues in the future with your accounts. You can reach out to me for basic questions and to find out if you even should be filing a complaint. But like I said, right now I am encouraging complaints to be filed, because that is how we are going to know what is going on with borrowers. I also refer borrowers directly to Department of Education. We work with the Bureau of Private Post-Secondary Education, BPP, which is the agency in California that licenses private schools, and then with the AG's office as well. And like I said, we can take further action as necessary. Next, please. Then one thing that I like to point out and just make sure borrowers are aware of student loan scams. So unfortunately, with everything going on in the student loan landscape, on the news, repayment, we have a lot of companies that are taking advantage of that. And I am hearing from borrowers a lot. So this is happening. So in order to protect yourself from these companies that are calling, they're texting, they're sending emails, just calling continuously. What they're doing is they're calling and saying that you have access to a program. They can help you with consolidations. They can help you with forgiveness programs. They're even reaching out to parents and new borrowers or students that are trying to access financial aid. So it's on both ends, not just with student loan borrowers. So it is very important that you protect yourself by knowing the name of your student loan servicer. You see Mohila, Nelnet Advantage, Ed Financial. Those are your federal student loan servicers. The ones on the right are some of your private lenders. So just know who you are dealing with, and know that you will be dealing with your studentaid.gov, which is the main Department of Education site. You're going to have that portal, and then your student loan servicer. You may have more than one servicer depending on your loans, but it is very important. Verify the information and research the company. If they call you, if you get a letter, read that fine print. Many times on the bottom, it'll say that this agency, this company is not affiliated with a government agency, but the seals look very official. So it's really important that you are looking out for those. Do not give out your login information or passwords. Do not subscribe to any monthly service or sign a contract. We are currently, I am working with a borrower right now who thought he was consolidating, provided all his information, and was being charged for 12 months about $200, which was not going to his student loan, to his account, to his balance. He could have done consolidation for free on the studentaid.gov, but again, was not aware that this was not a servicer. Just remember, there's nothing that a company can do for you that you can't do on your own for free. Loan servicers and the federal government are not going to be calling continuously from different numbers unless the account is past due or in dispute. They may call you in certain instances. But that is very rare. If someone is offering special access or there is a sense of urgency, just remember it may be a scam. Do not provide any information. Then a borrower, when they do sign up for these programs and they have to go and contact the bank, change their cards. I mean, they have to protect themselves because they could be at risk for identity theft as well, so many other issues. So they can, if you have been a victim, or if you're not sure, if someone reached out to you and you don't know if it's a legit company, you can email me, you can file a complaint with us. And then the Federal Trade Commission, the FTC, is also accepting complaints, and they are doing a lot of outreach on this because it is very prevalent right now. And I believe, is that our last one? I think we have one more slide. Oh, this is, so this is a press release or information on a settlement that was reached with a California student loan company out of Ramsey County. So a Network 46 was again charging fees and enrolling clients in a federal repayment program that they could have enrolled for free. um, they were charging the fees before performing the promised services. And again, many times these companies, which are like dog prepping companies or debt relief companies, many times they don't even know really about the process and what they're doing. So it could delay your actual process of consolidation of your applications if you have to meet a deadline. So just very important again to be careful with these companies because they are misrepresenting their services to students and borrowers. Next, please. Again, here are some links for the resources. The studentaid.gov page, the TISLA page, and of course our DFPI page. We do have a PSLF webinar on December 6th. Information is on there and then is posted there. And then as what Betsy said, next year we're starting a whole new webinar series as well. So thank you, everyone. Betsy, are there any questions that you want to answer or?
No, they took it much easier on me than they did on you. I'm happy to hang out for a couple minutes in case some questions trickle in. I just want to again thank Selena and the entire DFPI team for partnering with us on this series. It's been really exciting to be able to provide this information to so many people. Hopefully, it's been helpful. And again, I want to thank the Rose Foundation for providing us the grant that has allowed us to provide these free webinars to California residents. Um, I really look to California. I mean, California and Massachusetts tend to have really strong consumer protection laws when it comes to student loans, but California is definitely in the forefront of that, and they're leaders in that area.
Yeah, well, thank you, Betsy. I always learn a lot and I will be back on next year. And again, as I said, all the webinars are posted on our YouTube page, but we are always accessible via email. So thank you, everyone, and have a great rest of your afternoon.
I'm going to stop the recording.